still want to say something? Okay, I'm getting so many comments here in the chat box as well. Please, guys, go ahead and unmute yourselves. Kamran, you can go first. I think I saw your hand.
Okay, Assalamu alaikum. I'm Kamran Yusuf from Social Work Department. Basically, EDR is the process we can use. ADR can be confidential and flexible and avoid litigation, help avoid litigation that can devastate winners and losers. So it
Yeah,
also save time, save money, put parties in control. That's the reason.
perfect. Perfect. Yes. So, Ume Honey, I think you were second.
Yes, ma'am. In my way, the difference between the both ADR as well as it to going to court is the main difference is that the ADR is less expensive and time consuming way to solve any dispute between the any conflicted parties. While court, when you go to court for the salvation of the conflict, they have the long process and have lost of your money as well as time, and the conflict between the parties increase day by day when you come to the court. So I think that
Yeah.
is the main difference between.
Yes, that's absolutely right. Somebody else also has had their hand raised. You can go now. Okay, so I have so many messages in the chat box as well. You guys are all very much right, on the very right track as well. Quick solution to get instant relief. Yes, timely solution then court. Mutual communication, that is very good. Less cost and saves time. Yes. Promote lasting relationships. Yes. This is something which is very important to understand, that ADR is one of the methods that can promote lasting relationships. What does that mean? That means that people can come to mutually agreeable terms, right? When they're sitting against one another, when they're sitting and talking, having a dialogue, going into a private settlement, there is a very high chance that they can preserve their relationship, right? There won't be any fights. There can be fights, of course there can be fights. It's not like it's going to be very beautiful and very nice, that okay, a lot of people are sitting and just having a very fancy talk. It's not always that, especially in family cases. What happens is there are so many feelings that they're bound to just collide with one another, and I have seen this happen so many times, especially in cases of divorce or in the case of child custody. What happens is that the ex-married couple, what they do is they start fighting, and it gets really disgusting at that point as well. So it's not always that it's going to be very pretty and it's going to be very easy. It's very hard to bring both the parties to the table as well at times, because one party would be willing to go to a private settlement, the other one is not going to agree to go to it. So being ADR practitioners, being people who know about ADR, you have to be a little bit persuasive as well in bringing people to the table to have a discussion, right? It's not always going to be that both the parties are going to be willing to go to ADR or to mediation or to arbitration. So you have to persuade them to come to ADR and to resolve their dispute, right? How does this preserve relationships is because once all the fighting ends, they still have to come to mutually agreeable terms. What happens in court is that the court will decide in favor of one party. That is going to give aggression to the other party who is aggrieved, or who, let's say, took the case and did not win it, right? Or they were the opposite party. Now, what happens is that fuels aggression, that fuels frustration, right? What happens as a result of that is that there is aggression. You can pick Pakistan society and you can see that it's a very frustrated society, right? We have so many issues, societal issues, which are not resolved, right? So ADR, in my opinion, is not just a legal phenomena, it's not just a legal practice, but it's also a social restorative tool, right? What will happen is, if people are coming and having a discussion on their issues and they are able to resolve their issues by mutually agreeing to certain terms, they can definitely preserve their relationship, right? And that will benefit them in the future to refrain from getting frustrated, from refrain from getting aggressive, because they know that they will have to sit and have a discussion at the end of the day, right? So in that way, it can also lead to a societal restorative tool as well, along with being a legal tool, right? So this is something I like to tell people, that it is not just a legal phenomena. ADR is not just a legal phenomena, especially not for a country or a society like Pakistan, where we have fueling aggression and frustration. So we can use this tool to preserve relationships, to bring more harmony in the society, right? Okay, so moving ahead with the presentation, there are different modes of ADR. I think we are clear on what ADR is. ADR means not going to court, coming to a private settlement, right? Going to a private place, resolving your conflict through dialogue or through discussion. So there are different terms for that, different ways to do that: negotiation, mediation, conciliation, arbitration, and good offices. What is negotiation? Negotiation is a non-binding discussion. It's a non-binding way of resolving your dispute. There is no third party in negotiation. Like in arbitration or in mediation, you're going to have an arbitrator or a mediator, right? But for negotiation, you will not have a third person who will be sitting there and guiding you or deciding the matter for you, right? It's just going to be you and the other person sitting and coming to mutually agreeable terms. Mediation. Mediation is a method that involves a mediator, right? Now, what is the role of a mediator, which is very confusing to a lot of people in Pakistan? They think that the mediator is supposed to decide the matter. A mediator is never, ever, ever supposed to decide a matter. A mediator is only going to sit there and guide the process, right? Like, let's say if I am a mediator and I have two disputing parties in front of me, I can never, never tell them that this is what you should decide and this is what you should not decide. No. If a mediator, if you are in a mediation proceeding and your mediator does that, stop it right there. A mediator is not supposed to decide a matter for you. They're just supposed to guide the process. As I said, that in family cases, there are a lot of fightings, right? Ex-parents coming in, they're fighting, it's a nasty situation. So the mediator is supposed to be there to tame it down, right? They're just supposed to control the situation. They're not there to decide the matter for you. And the parties that are coming to mediation, they also need to be aware that a mediator will not decide for them. They have to decide the matter themselves. If they want an insight from the mediator, they can definitely request that. But again, it is a completely party-led process. A mediator is not supposed to decide for you. You can request the mediator to give his opinion or to just ask that, okay, what do you think about the situation? And he has to remain extremely neutral, he or she. He has to remain really, really neutral in giving that opinion as well. A mediator should not and will not give a suggestion or an opinion that favors one of the other party, right? With that, let's move on. Okay, so what's conciliation? Conciliation is again a non-binding thing like negotiation, but conciliation may involve a third party that can provide certain suggestions for solutions, right? They will, and they're not binding, of course. They're just like suggestions that, okay, this is something that you can do. This is a way to resolve your dispute. So that's how conciliation works. Arbitration. Arbitration is a more formal way of ADR. Mediation, negotiation, conciliation, these are a bit informal ways of ADR, of resolving your dispute through ADR. But arbitration is a bit more formalized way of resolving your conflict through ADR process. What happens in arbitration is, first of all, arbitration is always a product of an agreement. You cannot just decide one day and go to arbitration. The first and foremost requirement of going to arbitration is going to be an arbitration agreement or an arbitration clause, right? So that is why you will see a lot of arbitration in corporate cases or in consumer cases. A lot of arbitration does not take place for family disputes or for civil disputes. Why? Because let's say if I am there and I have certain terms with another civil person, I will not have a contract with him, right? So that is why a lot of civil cases or family cases do not go to arbitration. Arbitration is a product of arbitration agreements, which is a contract. It's a separate contract that is called as the arbitration contract or the arbitration agreement, through which the parties can decide to go to arbitration, right? Same can be done for mediation as well, but for mediation, a contract, a clause is not a requirement. For arbitration, it's a requirement, right? Another way of going to arbitration can be court referred arbitrations, that the court can say that you have to go to arbitration to do this. But that happens like very rarely until and unless you do not have a contract, you do not have an arbitration agreement. It's very less likely that you can be referred to arbitration. But for mediation, there is not a requirement to have a contract, right? You can just one day decide that we want to go to mediation and you can go to mediation. Okay, I think we have gone through what good offices is, so let's move ahead. ADR versus. Does anybody have anything to say? Okay, ADR versus litigation. I think we have also covered this as well. What is the key difference? You guys have been very phenomenal in deciding what these differences can be. So yes, it's a less time consuming process. Okay, one thing which I think needs to be told in true honesty is that ADR may not always be cost efficient, right? It does not mean that you would have to pay very less and your matter will be resolved through ADR. It is not always true, right? Sometimes ADR is going to cost you maybe a little bit more even than litigation. But there are so many other benefits to ADR, like you can decide your matter according to your own self. You will have control of the process. For arbitration, you can decide your own arbitrator as well. So in this way, ADR is better than litigation, even if the cost-effective feature is not there. Yes, Yasir, Yaqub, you can go ahead.
Ma'am, you said there was you can, I mean, decide it accordingly to your own, preferences. But has there been any example of abuse of ADR if the other party has less bargaining power?
Yes, that is a very good question, Yasir, and I'm really glad to hear that. Yes, this is a very important factor as well, which needs to be kept in mind. When there is an ADR process, let's say parties are going through mediation, right? One is a consumer. Let's say I have a problem against Limelight brand, right? Limelight is a big brand. I'm just one person, right? That party, that brand, that company has more resources, has more money, has more power against me, right? So in a lot of cases, what happens is that they will have, one party may have an edge over the other party, right? They can force you to come to a solution that is probably favoring them more. But you see, that is the beauty of ADR, especially mediation. If I am a party, if I'm a consumer, right, and I have a dispute against a big brand, a big name, and I can see that they have the edge over me, I can completely refuse to go to a solution with them. I can say that no, I don't want to have a solution with them. And what will happen is, now a lot of big companies, they fear going to courts. Why do they fear going to courts? Because they have a big name. If they go to courts, it's going to be a public proceeding, right? A lot of people can access that. Their name is going to be dragged down dragged down the dirt. They don't want that. So when you go to ADR, these companies, these big names will be, even if somebody has an edge over you, they will come to a term that is agreeable to you. Because if you say that I go to litigation, they will say, okay, fine, don't go to litigation. We can give you this thing, whatever you want, just so that their name can be secured. A lot of people try to abuse this as well, and that is why we have a mediator who keeps it under control. right? It's just to keep it under control. Mediation is not just two people sitting together. The process of mediation also involves separate sessions with the mediator, right? So in that, those individual sessions, what happens is that the mediator tries to tell them the situation of the other party, right? They try to tell them that this is what they want. What do you think about it? Right? So in that way, they have room. They can see what will be the benefit, what will be the negative aspect if they do not reach a mutually agreeable solution or an agreement. So yes, that was a very good question. And there can be instances when somebody will try to take an edge over you, but that's how you can control the system. That's how you can control the whole process. You can say, I don't want to go to any solution with them because they're not coming to a mutually agreeable term. And that's the point where they will come to a mutually agreeable term. Yes, Adnan, you have something to say? I think somebody else also raised their hand before. Ali
Ma'am,
Hussain. Yes, Adnan, please go ahead.
ma'am, is there a risk that the other party may not participate in good faith in ADR?
Yes, that can happen. That happens a lot of times. But you see, again, if the other party is not going through good faith, what will happen? They will try to come to a solution which is only agreeable to them, which is only beneficial to them. But being the other party, you have the right to stop that process right there and tell them that this party, this person is not acting in good faith. They are not coming to a solution which is agreeable to me. You have no obligation to come to a solution which is only agreeable to the other party. You can completely refuse and say, no, this is not the term that we agree upon. Mediation is always a mutually agreeable solution. You will always reach to a mutually agreeable solution if you go to mediation. Most of the times, it happens very rarely that both the parties will not be satisfied. Most of the time, 99% of the time, both the parties come out of the mediation proceeding with a mutually agreed term, right? And that is the significance of the process. If you're not agreed, you can simply say, no, this person is not acting in good faith. I do not want to carry on with the mediation proceeding. And then you can go to any other process that you want. Or what would happen is that the other person is going to be frustrated and they will say, it's fine, I'll just deal with it. Whatever you have to say, let's come to a mutually agreed term. So that is the process. That is the way how you can control the process as well. Ali Hasnain, but you had something to say, I think? Honey, you can go ahead.
Yes, ma'am. Ma'am, I have actually two questions. One is that if there is any dispute between the two conflicted parties, so who decide either is go for ADR or court? Either it is the party, any one party of the ADR which is involved in the confliction, or by the surrounding people to decide either this party go for ADR or to go for court.
Okay, so that's one question. Who decides whether you go to ADR or litigation? That's your question, right?
Yes, exactly. Yeah.
Yes. Okay. So as I said, there are different methods of ADR, mediation and arbitration. Let's just take, for example, right now, mediation and arbitration, right? For arbitration, I have said earlier as well that the parties need to have an already existing contract that if a matter or a conflict or a dispute arises between the parties, we will go to arbitration. And that mostly happens in corporate entities. You see, big companies, they do contracts, right? And in their contract, they usually include the arbitration clause, which says that if any dispute arises, we will go to arbitration, right? And if one party even goes to litigation, having that arbitration clause in their contract, that party can simply say to the court, the other party can simply say to the court that we have an arbitration clause in our contract. And by virtue of that, we are supposed to go to arbitration and not to litigation. And the court is bound to send you to arbitration. Now, if it's mediation, one thing to be understood, arbitration is always a product of a contract. the parties will have a pre-existing dispute resolution clause or a contract if they want to go to arbitration. For mediation, mediation can happen, let's say, in three terms. Okay, it can either be a product of a contract, just like arbitration. Okay, the parties can decide that we will go to mediation. Secondly, when they have gone to, let's say, litigation, one party has filed a case in the court, and now they have decided between the court case that they want to go to mediation. Any party can give an application to the court that, Your Honor, we want to go to mediation. And then the court is going to refer you to mediation. And if the parties decide to go to mediation, the court is bound to send you there, right? Okay. The other thing is, without having to go to court, the parties, without having a contract, without having to go to court, they just decide that we want to resolve this case through mediation. You don't have to have a contract for that. You don't have to go to court for that. You can just simply say that we want to resolve this case through mediation. Can I just tell you what mediation is? Let's not complex this concept. Mediation already exists in Islam, in Quran. You can find so many terms that refer you to mediation. Now, what is mediation? Mediation is basically just having a discussion. It's just about coming to a solution by having a dialogue. Our religion, our culture, it promotes this thing. What we as legal practitioners are trying to do it, that we are trying to codify this concept. We are trying to formalize this process, right? We're just trying to include it in the system in a more formal manner. Otherwise, if we just look at our society, if we look at our religion, this concept already exists. But we're just trying to incorporate it into the system in a more formal way, right? So I hope that answers your question, Umehani. Shehzad, you can go ahead.
Thank you, ma'am.
Assalamu alaikum, ma'am.
Walaikum salam.
Ma'am, actually, I want to ask a question. Are there any limitations to appealing an arbitration decision?
Appealing an arbitration decision. Okay, so yes. What you can do is that Pakistan has signed a treaty. It has signed a convention known as the New York Convention, which is the United Nations Convention on Enforcement of International Arbitral Awards, right? Now that is for international awards as well. What is an award? When a decision comes out of arbitration, that's called an award. Just like when you go to litigation, the decision is called as the judgment or the decree. When you go to arbitration, that decision is called as award, right? What you can do is that you can definitely appeal, but there are certain grounds to that. One very important thing, thank you so much for asking this question. What happens is that a lot of people, a lot of corporate entities, they can bar you from going to appeal. There can be a clause in the contract that says that if we go to arbitration, there will be no appeal from that judgment, from that award. And that is respected in a lot of terms as well. So, but if there is no such provision, you can definitely appeal. You can say that the arbitral award was against the vires of the law of Pakistan, or it was again, the parties did not have the proper right to present themselves. I would suggest you guys go through the New York Convention. You can find it on the internet anywhere. It's a very short convention, and Article 2 and Article 5 of the New York Convention, they deal with the grounds on when you can challenge an arbitral award. Okay, so go through it, and I just don't want to take a lot of time on that because that's on arbitration. So you can just go ahead, if you guys have interest, you can go through the New York Convention, Article 2 and Article 5 of the convention. These provisions deal with the grounds that can, using which you can challenge an arbitration award. Talha Irshad, Chaudhry Awais, you will be next. Talha, you can go now. You have your hand raised.
Assalamu alaikum, ma'am. I just want to ask that is there any legislation which enforces mediation like direct police or enforcement institution enforce the mediation order, or like would we would to appeal to court that this is a mediation order and court will order to parties, मतलब अगर आपस में conflict है तो parties को वो और कोर्ट ऑर्डर करेगी या पार्टीज विल बी पुलिस हमें बगैर कोर्ट के भी हेल्प कर सकती है?
Okay, that's a very good question, Talha. One thing that lacks in Pakistan right now is that we do not have a codified law for mediation. We do not have a law that regulates mediation. We have a law for arbitration, the Arbitration Act, but we do not have a law that regulates mediation. And we are working on that. The ministry is working on it. We have reached a stage where we have decided to ratify the Singapore Convention. What is the Singapore Convention? The Singapore Convention is, you can say, it's like the New York Convention, just like the New York Convention for arbitration. The Singapore Convention exists, which is for formulating mediation process. Right now in Pakistan, mediation is taking place under the ADR Act of 2017. It's formulated under that. We do not have a separate law for mediation. Once Pakistan ratifies the Singapore Convention, it will be put into our domestic law, and that will formulate mediation in Pakistan. I hope that answers your question. And I think there was a second part. There was a second part to your question as well, saying that how can parties go to it, right? I think we have talked about it as well, that the parties can, to enforce the mediation settlement. I think we will have to come to that as well. आगे हम इस चीज को discuss करेंगे. Mediation settlement is an agreement. Mediation settlement is a contract. When the parties reach to a mediation settlement agreement, there are two ways to go about it. Then, once you reach to a settlement, the parties write down that contract, the parties write down that agreement. Now there are two separate ways, right? One way is going to be that you just take that agreement as a contract. Let's say it's me and one other person. We have come to a solution. We have put the mediation settlement agreement terms in a contract. Now what we can do is that we can just take that settlement agreement and we can consider it a contract and abide by it, right? The second part is going to be to go to court and have it enforced as a court order. So what's going to happen in that way is that you will take a settlement agreement, you will go to the court that has jurisdiction to hear that case. Let's say if it was a divorce case, a district court has the jurisdiction to hear that case. You will go to that court and tell them that these parties went through mediation, they have come to this settlement agreement, and we would like to have this contract or the settlement agreement enforced as a court decree. And the court is then going to, if there are no violations of the law in that settlement agreement, the court is going to go ahead and execute that as a court decree. And then that turns into a court decree rather than being just a contract. Okay? Yes, Anila, this is one of another reason that dower problem can definitely be solved through ADR. Talha, I hope that answers your question. Chaudhry Awais, you can go ahead.
Assalamualaikum, ma'am.
Walaikum salam.
Ma'am, how a normal person can complain to ADR?
I did not get that. Your voice is breaking a lot.
How a normal person can complain to ADR in Pakistan on local area?
How a normal... Okay. I think your question is that how can a normal person go to ADR for their dispute, right? Yes. Okay. So again, a very good question. I'm really sorry. Unless your voice is breaking a lot, can you repeat that last point?
ਸੁੱਕੀਆਂ ਰੋਟੀਆਂ ਤੋਂ ਚੂਚੇ ਪੁਰਾਣੀ ਲੈਲਨ ਤੋਂ ਚੂਚੇ ਲਓ ਜੀ ਭਾਈ ਚੂਚੇ ਲੈ
Avais, can you please repeat your last point?
Ma'am, how can a normal person can go to ADR for complaint?
Okay. How can a normal person go to ADR? So what happens is that there are a lot of organizations that are working in Pakistan. I can hear you now. You can mute yourself. Okay, so there are a lot of ADR centers that are working in Pakistan, that are operating in Pakistan. A normal person can either just come and decide a matter for themselves, or they can go to these ADR centers. So there are some centers that are working in
Okay.
Pakistan, such as the Musaleha International ADR Center. We have IBA ADR International Center. We have International Center for Appropriate Dispute Resolution, that is in Islamabad. We have Sarosh ADR Center. So there are these ADR centers that are working in Pakistan, and you can just go to them and tell them that we have this matter and we want to resolve it through mediation. Thank you so much, Umar, for sending that message. I would really appreciate if you guys can keep yourselves on mute unless you don't have anything important to say.
Or in local area.
Okay, for local areas, there are centers. I am not very much aware. I think MyCader, the Musaleha International Center for Alternative Dispute Resolution, they have these centers in a lot of rural areas as well, especially the Legal Aid Society. I don't know if you guys know about the Legal Aid Society. You can search it up. They do a lot of pro bono work, right? They go to these rural areas if there is a need to anyone to resolve their dispute. They provide those kind of services in rural areas, in underdeveloped areas. Otherwise, in the major cities, we have a lot of ADR centers that are operating in Islamabad, Karachi, Lahore, in all these places. Okay, with the shortage of time, I think I'll have to just go through it. Okay, mediation as a session is majorly about mediation, and we will, I think, a bit here and there about it. Okay, so what is mediation? We have talked about it.
Okay,
Mediation
thank you.
is... You're welcome. I think your voice is breaking up, but I hope you got it all. Thanks. Okay, so what is mediation? Mediation is a non-adversarial path to resolving disputes. It can be non-binding, right? But we have talked about it, that there is always going to be a settlement agreement after the mediation. Let me just guide you through the process of mediation. So what happens is, parties file a case. I'll just take an example of an ADR center. Let's say we are going to MyCader. Okay, I am one of the parties. I have another party with me. We decide that we have to go to mediation to resolve the dispute. We don't have a contract. We have not gone to a court, right? We just one day had a dispute and we said that, okay, let's go to mediation and resolve this conflict, right? Let's say it's a divorce case or something. We decide that we want to go to mediation. We'll pick an ADR center, right? We will go to that ADR center and we will file our case to them. Let's say it's MyCader, right? So I will institute my case over there with my opposing party as well. Now the case is instituted, the matter is instituted. What happens next is that the center accepts your case and they contact you, right? That we have received your case. This is the problem. We accept it. If there is a deposit to be made, if there is any money to be submitted, they will tell you that please give this much money and so that we can start your process. You make that deposit. Now there is a next step. The next step is going to be selection of the mediator. Okay. Now, what is the selection of a mediator? This is a very important factor, and you guys are here, you're listening to this. Keep it in mind, a few terms, a few principles for selecting a mediator. If you are going independently to an ADR center, in the situation that I have just said, that I and another person, we decide to go to an ADR center, the ADR center is going to provide us with a list of mediators that they have on their panel. Okay, let's say it's a divorce case, so they will have mediators who have experience in taking care of divorce cases, right? They will give me and my opposing party a list of all those people who they have on their panel, right? And I and that other party will have complete right to decide anyone as our mediator. This does not happen in litigation. You can never decide who will be your judge. This can also not very much happen in arbitration. You cannot decide who your arbitrator is going to be. You can at some times, but maybe not always. But for mediation, you will always decide your mediator. The ADR center is going to provide you with a list, and you can decide your mediator there, right? Let's say you don't know the process, you don't know who is going to be a better mediator for you. You can ask the ADR center to appoint a mediator for you, given your consent. Okay, the ADR center cannot just go ahead and decide for a mediator for you. Aisha, I'll come back to you. Just give me one moment. Just let me finish this point. Okay. So another point. This is regarding ADR center. If you are going to a court, let's say your case was pending in a court, and then in the middle of that case you decide to go to mediation, what happens in that point? This is a very wrong practice being followed in Pakistan. What happens is, in court referred mediation, that in Pakistan these days, the judges are deciding for your mediator, which should never be the case. This is a big flaw in the system which needs to be rectified at this initial stage. Otherwise, it is going to lead to a lot of problems. And the mediation processes cannot be implemented in its true spirit. So what happens is, nobody can decide for a mediator for you. The parties will always have the right to decide for a mediator for yourself. Okay? And you need to be in control of that. You go to an ADR center, they will give you a list, and you will have to decide for your mediator. You are going through a court referred case, the court should provide you with a list of the mediators that are enrolled, that are certified, that are notified by the government of Pakistan. And then from that list, you can decide for your mediator. If you cannot decide, then you can ask the court to decide a mediator for you, but only if you give your own consent, right? So this is how the mediator is selected. Aisha, you can go ahead. Aisha, you can unmute yourself.
अस्सलाम वालेकुम मैम। मैम अगर आप देखें तो कुछ जी 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 मैम अगर आप देखें कुछ कॉन्ट्रैक्ट्स में आर्बिट्रेशन क्लास लिखी होती है ना, तो अगर एक पार्टी उस आर्बिट्रेशन क्लास के बावजूद भी कोर्ट जाए, तो आया कोर्ट के पास जुरिस्डिक्शन की, मतलब उसके पास मजाज है कि वो उस पर फैसला दे कि नहीं, वो आर्बिट्रेशन क्लास ही रेफर करेगी कि इसको उसी के जरिए हल करें?
Okay, that's a very good question, Aisha. And no, if there is an arbitration clause in a contract, if there is an arbitration contract between the parties, the court cannot have jurisdiction on that case unless the parties go to arbitration. Unless they go to arbitration and they exhaust that measure, then the court, if they do not reach to a conclusion in arbitration, they can come back to the court. But without having to go to arbitration, the court can never pass a judgment if there is an already existing contract. So what happens in practice is, I can be wrong about it, but I think it's section 28 of the Arbitration Act of Pakistan. So what happens is, if there are two parties and they had an arbitration agreement, they had an arbitration contract to go to arbitration, but one of the parties filed a court case, they took the other party to the court, the other party will have the right to give an application. I think it's section 28 application of the Arbitration Act. I can be wrong, you guys can check it up in the Arbitration Act. That party can give an application to the court of section 28 that, Your Honor, court, there is an already existing arbitration contract and we have to go to arbitration before we can come to court. And once that application is submitted, the court will have no other way around than to send you to arbitration. If one party gives that application and the court still proceeds with the case, it's not right. They have to go to arbitration if there is an already existing contract of arbitration. I hope that answers your question.
Okay, thank you so much.
You're welcome. Okay, so coming back to what is mediation, does anybody have anything to say? Kamran, you can go ahead.
Yeah. Assalamualaikum, ma'am. I have a question.
Yes.
Like, who can become a mediator for resolving the issues? Do they have to be do they have to be a litigator?
Okay. Again, a very good question, Kamran. I am really happy to see you guys asking so many insightful questions. This is really amazing. So yes, who can be a mediator? A mediator can be anyone. You don't have to be from a legal background to be a mediator. So another beauty of ADR is that you can decide your own mediator or your arbitrator, right? Let's say there is a case of construction. There is a matter regarding construction, right? Why these cases take so long in court is because the judges are not specialized in a lot of areas. If it's a construction case and we go to court and the judge has no experience in construction cases, that case is going to take ages to be resolved, right? Because the judge will have to learn the construction process, they will have to know what the nitty-gritties are, and then they can decide. But what is the significance of ADR is that you can pick an arbitrator or a mediator that is an expert of the field in the dispute that you have. If you have a construction dispute, if you have a very specific dispute which requires expertise, for example, construction, right? That's a very specific domain, right? You can decide an arbitrator or a mediator that has experience or that has expertise in that area of practice, and they can decide the matter for you. So an arbitrator or a mediator can be anyone. They don't have to be coming from a legal background. It can be a business person, it can be a construction person, it can be literally anyone. Anyone can be an arbitrator or a mediator, provided that they go through certain trainings. For an arbitrator, you have to go through a separate kind of a training, and then you are an accredited arbitrator. I think you guys see a lot of these things on LinkedIn or on such platforms that I'm now an accredited arbitrator or an accredited mediator. So these are accreditation forums, these are accreditation programs through which you have to go through, and then you can be a proper professional arbitrator or a mediator. But it can be, these courses or these programs can be done by anyone. You don't have to be from a litigation or a legal background, if that answers your question, Kamran. Okay, Yasir, yes, please go ahead.
Ma'am, if an arbitrator has a relationship with one of the parties, can the process still be trusted?
No. Let's say if I am one of the parties and you are one of the parties, the arbitrator has a connection with me, right? They are related to me, or they have some sort of relation with me, right? They are, let's say, my colleague, they're my senior, they're my boss or something. If you know that, you can completely ask that arbitrator to be removed. You can say that this will compromise the confidentiality, this will compromise the sanctity, the transparency of the process, and therefore we request for this arbitrator to be, or this mediator to be removed, and they will be removed. Okay. All right. Coming back to mediation, I think we went through the process, go through, file your case, select a mediator, and then the mediation starts, right? So when the mediation starts, there are two things that happen during mediation. There are combined sessions in mediation, and there are two separate sessions as well that are taking place, which are known as caucuses. Okay, and what happens in caucuses is the mediator spends individual time with both the parties, and they try to explain the points of the other party to that one party in a caucus. I will not go into the detail of the process of mediation. That can be done maybe in a separate session someday. So mediation is basically a settlement agreement in which there is a mediator who only facilitates the process, who does not decide for you. The parties are going to sit there and decide for themselves. you have to act in good faith. If you want to come to mediation, you will have to do it in good faith. You will have to be honest with the process. If you're not honest with the process, mediation cannot take place. And this is one of the issues in Pakistan, why we are not able to execute this mediation process in Pakistan is because a lot of parties, they don't act in good faith. There are so many frivolous litigations ongoing in Pakistan. They just file a case for the reason of defaming another person, that when they come to ADR, they're not willing to participate in good faith. So if you actually want to resolve your dispute, you will have to go through it in good faith, right? Ramesa, you have a question? Please elaborate difference between good offices and mediation. Okay, that's very basic. Good offices, what is good offices? Good offices is just a third party providing you a space, right? I'm a third party. You and a friend of yours has an issue, right? You want to go to ADR, you want to go through a private settlement, but you don't have a place. You don't have a neutral place to go to resolve your matter, right? Let's say, Romesa, you are country A and your friend is country B. This usually happens on international level. So good offices is something that happens on international level, right? Mostly. Why? Because two countries are at conflict, two countries are at dispute, and they cannot find a suitable place for themselves, right? Let's say it's let's say it's England and it's UAE, right? It's Dubai. These two countries, they are at dispute. Now they cannot go to Dubai because then the party coming from Dubai will have an edge, right? Or they cannot go to England because then the party coming from England is going to have an edge. So now they need a neutral place where they can go to and decide their matter. In that position, what happens is that a third party intervenes. Let's say that's me, right? And I would say that, okay, I'm Qatar. Okay, I'm Qatar. I will give you my place. You can come here and you can resolve your dispute. And that's me providing you with good offices, right? What is mediation? Mediation is just simply resolving your dispute through dialogue, right? Good offices can be in mediation, it can be in negotiation, it can be in conciliation, it can be in arbitration. So it's just good offices is basically providing a space, right? Mediation is the process. So you can have good offices for mediation, you can have good offices for arbitration, you can have good offices for negotiation, right? So I think that answers your question. And mediation is just a process that you go through to resolve your conflict. Yes, Anila, again, that is a very good question. Different types of ADR after mediation. That is a very, very amazing question. Okay, so there is a practice, there is a concept known as multi-tiered dispute resolution clauses. I will write it in the chat box. Okay. It's called as multi-tiered dispute resolution clauses. This happens a lot in corporate cases, right? When they have a contract, when parties have a contract between themselves. Civil people, you and I, if we are having a discussion, we will not have a contract, right? But if we are two corporate entities, we are going to have a contract to our agreement. Now what is happening is that there is being a practice followed, which is known as multi-tiered dispute resolution clauses. So what happens in this is that the parties decide to incorporate different ways or different types of ADR in their dispute resolution clause. So parties decide that first of all, what we will do is that we will go to mediation, right? If mediation is not successful, we will go to arbitration. And if arbitration is not successful, we will go to litigation. So litigation is always the last step for them, right? For different reasons. So this is called as multi-tiered dispute resolution clauses or a multi-tiered dispute resolution process as well. That the parties decide that we will go to mediation, then arbitration, and then litigation. This can again take a lot of time and we are already past the time of the session. So what happens is, another important point is multi-tier dispute resolution process. In Singapore especially, Singapore is one of the leading jurisdictions on mediation. On ADR, Hong Kong is a very leading jurisdiction on ADR. What they have started is, it's called as ARB Med ARB process or Med ARB Med process. ARB Med ARB and Med ARB Med. These are two processes. Okay. What happens is the parties can decide that first we go in, let's say ARB Med ARB, right? What can happen is the parties can decide that we will go to arbitration, and then within that arbitration, they say, no, arbitration is not working for us. Let's try mediation. They will go through mediation during the process of arbitration. And then if mediation is not successful, they can go back to arbitration. Okay? That's ARB Med ARB. Then we have Med ARB Med. What happens is parties decide we go to mediation first. They're going through mediation. They're trying to resolve their conflict. What happens is parties cannot come to a mutually agreeable term. They can decide that, okay, we are not able to come to a mutually agreeable term. Let's try arbitration. During that mediation process, they can go to arbitration. Okay? Arbitration is successful, their case is resolved. If it's not successful, they can come back to mediation. So this is called as Med ARB Med. I hope that answers your question. Yasir Yaqub, you had your hand raised for quite a while. Do you have something to say?
No, ma'am.
Okay. Zarar, you have a question. If we are not satisfied by litigation, so what will be our next step? If you're not satisfied with litigation, you can go to ADR. Simple. ADR is, I think, ADR is the most beautiful procedure for dispute resolution. You have gone through litigation, you're not satisfied with the decision that came out. You can now take the other party to ADR. You can simply tell them that this did not work out for us. Let's try an ADR process. And let's try to resolve it through that. Before litigation, you can go to ADR. During litigation, you can go to ADR. After litigation, you can go to ADR. It's completely up to the parties. If you're not satisfied by the litigation decision, you can definitely go there. But again, it would depend on the other party. Let's say that the court's decision was in favor of the other party. They will not be very much willing to go to ADR again and start the process again with you, right? That can happen a lot. So in that way, you need to know whether the other party is going to be willing to go to ADR, mediation, or arbitration or not. Hussein, you said with both the parties' consent. I did not get that. I think you're asking that whether ARB Med ARB can be changed. Yes, this can be changed, but mostly it exists in the form of a contract. So parties, before the dispute arises, they can have a process decided in their contract that we will go through an ARB Med ARB process or Med ARB Med process, right? And again, obviously, it has to be from the parties' consent. ADR's foundational principle is party consent. All these processes are party-led. Mediation especially is very much party-led. So if the parties are not agreeing, it cannot happen, right? So yes, with parties' consent. Thank you so much, Sikandar. These two processes are a choice for one to choose from. There are different processes, as I said, because mediation is taking prominence, arbitration is taking prominence. So now there are different types of processes that are coming in. ARB Med ARB and Med ARB Med. These are two different types of processes that have now come in. So yes, parties can decide from that. Munir Ahmed, you have a question related to the colonial policies and laws which are mostly practicing in Pakistan. What do you think? Are they beneficial for a society or is violating the status of human? Okay, let's come back to that at the end because it's not very much related to the topic. How can technology be used to enhance ADR while ensuring that it remains secure, accessible, and fair? Okay, Yasser, technology, that is a very active discussion. How can we utilize that? When we talk about technology, our second thought goes to AI, right? But there is a lot of other technology as well that is being utilized for dispute resolution. What happens is ADR, now there is a term called as ODR as well, okay? Online dispute resolution. So that is one way of utilizing technology for dispute resolution that is happening in Pakistan as well, especially in the higher ADR centers such as ICADRP, International Center for Appropriate Dispute Resolution and Prevention, that is in Islamabad. They are using the process of ODR. In England, that is being happened. A lot of people in Pakistan are now certified by ADR, ODR International, which is an organization in itself. So yes, there are a lot of ways technology can be used to enhance ADR in a lot of ways. Anik, yes, please go ahead.
Thank you so much, ma'am, for this comprehensive discussion. Um, I have a practical question related to the future of ADR in Pakistan because you are, I think, you are currently practicing in ADR. My question
Yes.
includes the first thing is what to do to become a certified mediator or arbitrator, and the second thing is what may be the approximate ratio of ADR cases as compared to litigation in Pakistan.
Okay. How can you become an arbitrator or a mediator? Let's cover that first. So to be an arbitrator, you have to go through a training. So there is the most prominent institution that is providing arbitrator-related trainings is Chartered Institute of Arbitrators, CIR. I think you guys would have heard about that. So that institute, that organization provides trainings for arbitrators. And you have to go through that training to be accredited, right? Because in Pakistan, what happens is once you get trained, once you're certified by a certain organization, you can get notified by the government, right? You can file an application to the Ministry of Law and Justice and tell them that we have taken this training, we have completed these many hours of the training, and we are now certified arbitrator, and we would like to be notified by the government or by the ministry. And you can file an application and they will accredit you for that, provided that you meet the criteria for that, which is training. You have to be trained to be an arbitrator. You can be from any background, you don't have to be from a legal background, but you will have to go through a training to become an arbitrator. Same is for mediator. You have to go through a 40-hour mediation training. It is the baseline requirement. It is a worldwide practice of 40 hours of mediator training, right? And Pakistan also practices that. You have to have a 40-hour mediator training. And after that, again, you can send an application to the Ministry of Law and Justice and have yourself notified as a mediator. And then you will be on the list of the nationally notified mediators. And then if any case from the court has to be taken to mediation or arbitration, you will be considered on that list to be acting as an arbitrator or a mediator. Okay. What was your second question? I think it was ratio as to ADR and litigation. So right now, a lot of cases are still going through litigation, which is a very drastic sight to see. Courts are burdened, we understand that thing, but courts are there to resolve your dispute, right? A lot of people keep saying this, that the courts are burdened, courts are burdened. Courts are there to resolve your dispute, they have to be burdened, right? But why we think that this should be changed is because the people need to be aware that litigation is not the only way to resolve your dispute. You can go to other processes as well, as we have discussed. You can go to mediation, you can go to arbitration, you can choose your own process to resolve your dispute, right? But so far we are still creating awareness, just like I'm sitting here creating awareness on this. So now you guys are very much aware of this process. I think take this session and educate people on this process, that ADR is a way for this. Yasir, I'll come to your question. Just one thing I would like to add. While you guys are creating awareness on this thing, keep in mind that ADR is not favorable for all kinds of cases, right? We are all talking about it. We are very interested in the process, but keep in mind that it is not favorable for all types of cases, right? In my opinion, the best use of ADR is in family cases and in civil cases. Why? There is another reason for that. Why I say that family cases are very perfect for ADR is because those are family disputes, right? Those are private disputes. It's better if these disputes are handled more privately and confidentially, right? You shouldn't have to go to court. Women, children, men, they don't have to go through the overwhelming, the abusive process of litigation in Pakistan. They can just sit there and decide for their matter. They can decide for the custody of their child. They can do all this. So this is one way of utilizing ADR. So if, let's say, you come through a process, you guys are, mashallah, so very talented. If you see a problem, if you see a case, if you see a person who has to go through divorce, you tell them, go to ADR. Okay? Resolve your matter by sitting together. You want a divorce? Our religion does not ask to have a court decree for a divorce or for a khula, right? Our, it's not written in the Quran that you have to go to the court and you have to get a decree to be divorced, right? You can just sit there and you can decide for that. You have a child custody case. The Quran does not say that you have to go to the court and get the custody decree. You can just sit together and decide for yourself. So whenever you come across such a case, try to tell people, try to educate them on this thing, that litigation is not the only way. You don't want to live together anymore? Fine. Resolve it amongst yourself, come up with the solution, and go your separate ways. This is one thing that I would really like to emphasize on, that ADR is best suited for civil cases and for family cases because they're always family related. And there is no harm in sitting together and deciding for your matters. So that's one thing to keep in mind. Some people prefer litigation. Why it is so? For several reasons. A few reasons why I would add that is that people prefer litigation is for, I think there are three most important points why people would go to ADR, why people would go to litigation. So one thing is they want a decision that is binding. They want a third party to decide for them, right? They think if they go to litigation, they will get the case decided in their favor, and they want to, what happens a lot in Pakistan is that they're trying to teach a lesson to the other person, that I'll see you in court, let's do this, I'll do that, I'll do this. So for that reason, they go to the court just to teach the other person a lesson, right? That's why they will prefer litigation. Another reason is to have a decisive decision for you. You don't have to decide your matter. A third person is there to decide for you. People like that. People want another person to decide for you. So they can definitely go there. Another reason why they would go to litigation is for execution. If there is a court decree, if a court decides something, that is to be executed. It does not depend on both the parties that whether they will execute it or not. If it's a court order, they have to abide by it, right? So there is an enforcement protection in litigation. So that's the reason why people go to litigation. Zarar, if you're still asking this question, why choose ADR over courts? I think my session was a big fail and I was not able to tell you why ADR is better than courts. I think this session was all about why to choose ADR over courts. Yasser, you can go ahead.
Ma'am, since there are conflicting interpretations of Sharia law and civil law, especially in cases involving inheritance, divorce, and child custody, how can ADR mechanisms be effectively implemented?
There are a lot of, yes, conflicting opinions on that, but that does not mean that the parties are still not able to resolve their dispute, right? What we can do through ADR is that parties can just come together and decide for it. They don't have to look at Sharia law, or they do not have to look at the civil law. They just have to decide what they want to do, right? And that is why they should go to ADR, and that's how you can use ADR. You don't have to look at Sharia law there. That is the point. You have raised the very important point that I was trying to say, that if you go to the court, there are only conflicting opinions. The cases take so long because there are so many conflicting laws, there are so many conflicting opinions, and you're just confused by all of that. The judges are confused by all of that. A simple case will take 30 to 40 years, right? So that's why it's important to realize that you don't have to look at a Sharia law, you don't have to look at the opinions. Whatever you want, you can decide for it and go to ADR. Go to mediation, come up with a mutually agreeable solution, write it in a settlement agreement, and you have your solution for that. You're not looking at Sharia, you're not looking at civil law. Okay, Sarar, I think again you came late, but still the session was all about that. Why are we going to ADR over courts? Let's come to that at the end of the session, and I'll ask somebody else to explain that to Zarar as to why we should go to ADR than courts. Usually in villages, people do not sign a contract even in matter of contracts. They believe in oral communication. Can we also solve this case? Yes, Anila, yes. We can do anything through ADR, especially mediation. If there is no existing contract and the parties still have a dispute, they can go to ADR and say that we came to this solution, we came to this matter, and now we have a dispute. Let's resolve it through mediation. Let's sit together and let's decide. In that way, what happens is that they will come to a solution that is agreeable to both the parties, and they will put it in the form of a settlement agreement, and now that is executable. So yes, they can definitely do that. If one party wants to go for ADR and the other doesn't, should they pursue litigation? Okay, very insightful question. I think we have gone through this. There will come a point when the other party does not want to go to litigation, not want to go to ADR, right? So that is where your persuasion is going to come in, right? That is where you will have to persuade them, you will have to decide for them, you will have to tell them why ADR is better for you, why not go to litigation. And if there is an already existing dispute resolution clause, then the parties are bound to go to an ADR process. But if there isn't, you can just bring them to the solution that let's go to ADR, let's not go to litigation. Yes, Kamran, basically ADR saves time, saves money, it's flexible, obviously, because you have the reins in your hand. You can decide how you want to take the process and you can go ahead. Adnan, you have something to say? Yasir, you can go ahead.
If ADR becomes more common, how will this impact the evolution of legal principles and consistency of judicial decisions?
Judicial decisions are not going to be impacted by this, because let's say if there is an arbitral award, arbitration has taken place and there is now an arbitral award. To execute that award, the parties will have to go to the court to have it executed, right? That the parties went through arbitration and now they want to resolve, they want to execute this arbitral award, right? Now what will happen is the court is going to take a look at that award and they will say, okay, this is completely fine. It is within the vires of the law. It is not ultra vires. It is not illegal. Everything is according to the law. And they will pass a judgment that, yes, okay, this award is fine. Let's execute it. For mediation settlement agreements, there, as I said, there are two terms. The parties can either just take the settlement agreement and abide by it in the future, or they can take it to the court and have it executed as a court decree. So in that way, the court's decisions are not completely, they're still there because they're deciding whether this arbitral award or this settlement agreement is to be executed or not. Yes, sir.
Ma'am, generally they do not produce publicly available decisions. Don't you think that can limit the development of case law and legal norms?
Okay. Yes, very important point. While ADR is a very confidential process, we understand that it is very confidential, right? A lot of cases are not published, but there is one thing which needs to be kept in mind. Although it is confidential, but when it comes to international cases or even national cases, what happens is that there are two types of confidentiality. One confidentiality is that the case is published, the case is made public, but the names of the parties are not disclosed. So they would just simply say that there was an American party and a British party who had this dispute, and they did this thing. So in that way, the case law is still there, but the names of the parties are not there, right? Another process is complete confidentiality. Why do we need case laws? We need them to a certain position, right? When we're going to the court, we take a certain case law and we say this was decided in this case, and that is why we want to utilize this case. You already have a lot of practices, right? You have a lot of case laws already existing in Pakistan. I don't think if let's say I have a question for you, Yasir. Let's say in Pakistan people start utilizing ADR and there is a significant change and there is a significant downfall in disputes in Pakistan. Do you think this is still a concern that the cases that are happening in ADR, they're not made public and we cannot take it to the court? Would you prefer resolution of disputes or would you prefer case laws?
Obviously, resolution of disputes.
Exactly. That's a very simple question. So while they are resolving your disputes, it's completely fine. You don't have to have a case law. We already have so many case laws that are existing that we can utilize. So if something is going down the right way, they're able to resolve their disputes. It doesn't matter if the case law is coming out or not, right? And does anybody else have any questions? Okay, so we did not go through the whole presentation, which is completely all right. I wanted this to be a more engaging session. I'm really, really happy to have you guys ask so many questions. I thought this was going to be a very silent session, but it really wasn't. And I am very, very, very happy to see you guys here. We have already gone almost 27 minutes past the deadline. And thank you so much, guys, for being here. If you guys have any questions, I can leave my email in the chat box and you can reach out to me if you have any questions. Anything that you guys have, procedural questions, substantive questions, I'm happy to help you guys. And it's just been amazing being here and listening to so many good questions, answering so many good questions. For all the people who have joined from outside of Pakistan, thank you so much, guys, for your time. And I hope that this session was up to your expectations. Thank you so much for joining us today.
Thank you so much, Miss, for your time and invaluable insights about the ATR. And I am really excited to learn about mediation, arbitration, and litigation, as I was not aware about it before then. थैंक यू सो मच। और मैं उम्मीद करता हूँ कि बाकी जितने पार्टिसिपेंट्स हैं उन्होंने भी बहुत कुछ सीखा होगा इस वाले से, और आप अपनी प्रैक्टिकल लाइफ में इसको आगे जाके इस्तेमाल करेंगे। बहुत ज़्यादा आपको फायदेमंद, और उम्मीद करते हैं कि इस तरह के क्वेश्चन आप लोगों के साथ जो है कंडक्ट किए जाएंगे, करवाए जाएंगे। अगेन थैंक यू सो मच मिस।
You're most welcome. Thank you so much, guys, for your time. Thank you so much. I want to appreciate your organization for allowing me to present my thoughts here. It has been an amazing session. Ume, honey, you have something to say?
Yeah, ma'am. Actually, unfortunately, I miss your email ID. Please, can you please send again your email ID in the inbox?